There we are. I think that's live. Greetings, 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 greetings to anybody out there. Anybody. So if you see it now, then hello, welcome. Like Ricky, I like that name. Let me look over this way. Marty. Whoa, this is great. Again, when I was a kid growing up, they're little kids. This is back in the 1850s when I was a little kid. There was a show on TV called Hobo Kelly, and she was a hobo when that was allowed to be used as a word. And during the show, what she would do is she would look out. There's little Billy, and she would wave to it. So it's funny to me when I look to my, I always have to bend. It's to my right, might look like to your left, to call out like Pete the Greek, and Tim and Lee. I think everybody else I've mentioned there. Anyway, it's funny. It's funny to me, based upon the Hobo Kelly scenario. So earlier in the week, this is about GTII. I'm going to do something about tariffs tomorrow, I think, because of course I have some kind of position on that, but I don't want to confuse the two. And I wanted to kind of bring everybody kind of up to date about GTI to some degree. Last week I was bitching, and during the week I posted several tweets that I thought were suggesting progress that was being made, but I wanted to do a video to address that more specifically. So that's kind of the purpose of today's video, to go over what is now in the public record in court orders, and to explain it all, and so you all be up to date. And as I promised, transparency, that's what we promise. So we will do it. And these are all in the public record. So it can't cause any harm to anybody because it is what it is. But of course, before we, and this is obviously not legal advice to the extent that even if it could qualify as legal advice, it isn't. This is meant, quote unquote, for entertainment purposes only. And if you're entertained by this stuff, then I can't help you. Sorry about that. Anyway, what did the shark say to the plate of sushi? Pleased to eat you. And what did the shark say? This happens to be one of my favorite jokes, by the way. What did the shark say after he ate a clownfish? That tastes a little funny. And what is a great white shark's favorite sandwich? Peanut butter and jellyfish. Anyway, so what I wanted to talk about, and there's other ones. I got I'm loaded with jokes here. So if you wanted me to do like 15 more today, I'll do 15 more, but I think I'm going to quit while I'm ahead or not too far behind. So three things I'm going to talk about. There was an order we talked about, at least I posted now, so maybe you saw it or maybe you did not. It referenced some agreement as to a Liz pendants involving David Reichman's property in LA. So that's one thing we're going to talk about. Second thing was some agreement with regard to .8. I think that was connected to Justine Reichman, who's a non-party to these proceedings, but I think she's been involved in discovery in some ways based upon the documents, and it relates to some turnover of shares of .8 plus money from various bank accounts. And the third thing I'm going to address is the audit, those kind of three things. So just starting first with the David Reichman stipulation. So the parties agreed. So does that mean one party said, yes, I want this, and the other party said, yeah, and we're done? Probably unlikely. I think the agreement, I probably more than think, the agreement involving David Reichman and his particular condominium located in West Los Angeles was negotiated between the Receiver's Council and had to be signed off by the receiver, and a counsel for Reichman. And I think he has multiple counsels, so I don't know which counsel was involved. But since it's a stipulation, there had to be some agreement, and probably wasn't an immediate agreement. And there's no final decision as to the status of the property. More, and this was something I was asking for, and I'm glad that these guys did this and accomplished this, and I have to give them props for doing it, of course. But it basically ties up the property. So once the a lis pen, so there's an agreement that they can record a lis pendens against the property, and the lis pendens is a notice that's recorded against the property that gives notice to the world that there's a dispute about this property, and then no action can be, and in effect, it stops any future transactions involving the property until that lis pendens is removed in some fashion. It doesn't fully resolve the status of that property. The property is a condo. A condo in California means you own the unit, but everything else is owned by it is considered common area, and is really owned by the association. You own your unit and like a percentage of the association. You have to pay dues, etc. That unit's worth I'm basing this upon Zillow, so this is an approximation, somewhere in the order of 1.5 to 1.6 million, according to my own research. And apparently and again, I don't know these facts firsthand, so I know them for reading the document, and I'll just show you what I'm looking at. Ooh, that's an interesting effect. The Invisible Man. That invisible document that you just saw, that's a portion of the order, just so you know. And I'm just reading from that. And in it talks about the agreement and what was going on. And it suggests, so I'm now summarizing what it says. So apparently before the receiver was appointed, David Reichman acquired this condominium on Wilshire Boulevard in Los Angeles. I'm not going to give you the specific address for obvious reasons, but on Wilshire Boulevard in Los Angeles. I don't know the timing, if it was a day before or like 15 minutes before or months before, but it was before the order appointing the receiver was in there. And obviously the receiver has a claim as to that property, and that's why there is a lis pendens attached. And the receiver's claim would be for the benefit of the state of GTII, of course. So he acquires the property. There's an order obtained where and I guess he starts fixing up the property because it needed some work. So he incurs a cost with a contractor. I don't know if there's any kind of mechanics lien. So if you're a contractor and you perform services to do construction on a building, for example, and there's certain processes you have to file certain notices, whatever. But at some point in time, because you've put out services on this property, on this construction project, you can record something called a mechanics lien, and it's against the property, and it protects the contractor if they're not paid. In essence, if eventually it's not paid, then they can foreclose that lien. Like a foreclosure. You've heard of foreclosures. This is another way of being able to foreclose that lien. So apparently there was like 380, according to the stipulation, like $380,000 owed to that contractor. There's some amount of money that's owed to the homeowners association, and some amount of money owed for insurance. And according to this, Reichman's accounts have been frozen, so he doesn't have access to any cash. The problem for us is if these amounts aren't paid, then that asset, which seems to have a good amount of equity, could be lost. And how do I base the fact that there's equity? Well, again, I looked on Zillow, and that may not be accurate, but I think when I looked today, it's at least timely. I looked and it had a value. The high value was somewhere in the order of 1.66, and the low value I think was on the order of 1.39. So I picked 1.5 as a number. So using that 1.5, which is on the lower end of that scale, and I noticed there's no money here for a mortgage payment, so it suggests that there is no mortgage. I'm presuming that because it's not referenced here. And if there was a mortgage and they were late on the mortgage, I would presume we would see that in this calculation. Obviously, something that I will confirm because it's a few things I'm going to confirm. But just looking at these, if you add all these numbers together and you had to pay them out, that it's about $400,000. That would leave still $1.1 million in equity, and that's an appreciating asset. Presumably, it's not in a fire area; it's in a nice area of the west side of LA. So it's an appreciating asset. So we GTI should protect it, and they are. And if that contractor is not paid, then they will be able to foreclose and take the property and the equity. So obviously, it's a no-brainer that it's going to be done. So just for the limited purposes of being able to pay all those things I mentioned, he's going to have access to his accounts just to pay those. And I'm sure there'll be some process to protect that. So it's no more than that. And this could change. It may be future amendments, but whatever. It protects the asset and the equity in an appreciating asset. And to some degree, as you will hear in the second order, there is some balance to that money for the contractor, and you'll hear it when I get to the second order. And it's basically, it says that we have claims, we being GTII has claims, and that they worked out some agreement, and that's the agreement, that they have the opportunity to pay those, that the receiver has the right to, and I guess the actual total is $408,525.47 for that specific amount. And additionally, then the without objection, without being able to object, and I think there's a bankruptcy prohibition also, that a lis pendens can be recorded. This is dated March 25th. I don't know if the lis pendens has been recorded yet. I will certainly follow up on that, but it gives them the right, and in essence, they can't object to it. So there's a protection against any further distribution. And again, signed by the attorney for the receiver and a couple of attorneys, from a couple different law firms on behalf of David Reichman. So that's the first order that came down last week. So this is basically freezing the condo in West LA that has, in my mind, $1 million. This is my mind, not indeed, not firm, not certified, whatever. Based upon my knowledge of the property, I live in LA, so that gives me a little better idea. But based upon my very casual research and my understanding of the property, at least $1 million in equity, even after paying those fees, and it should be an appreciating asset, especially after it had been remodeled. Plus, there's a lis pendens against that, so it's frozen. And it's the other thing you have to think about is it's better that it was agreed upon as opposed to litigating it, because even though if you had to, you should, because there's no reason not to. But if you can get it negotiated and done in a more casual, informal manner, then you don't incur all the legal fees, and we're in essence responsible for the legal fees of the receiver, in essence, because that comes out of the estate. So I understand why they would, if they're able to negotiate something, and it's not too much of a pain in the butt, and they think that the other party's operating in good faith, or their counsel is operating in good faith, then they're more inclined to give more time and try to negotiate something in good faith. So here we have the asset is tied up. It doesn't reference anything else. I know that that the receiver and their counsel are out still trying to, and this applies to all the shares outstanding, are trying to go after all the shares that are outstanding that are available. I would guess, but I don't know because haven't spoken to the receiver, and he would, to be honest, the receiver has no obligation to speak to me directly or anything like that. I try to inform everybody and state my opinion, but they have no obligation, and I understand also why they would not want to. So it makes perfect sense. but I know that they are out there seeking all the shares. So if they're seeking all the shares, and if their shares belong to Mr. Reichman that we all think or maybe shouldn't belong to, then I presume that he's engaged with those shares too. That would be, I think, a reasonable presumption at this point in time. So this is the first step, which I think is really good progress. It also might reflect future willingness to negotiate on the transfer of large amounts of shares. At least I would take that as the first inclination. I would be pleased because, again, according to the receiver's reports and according to, whatever I deemed and whatever our counsel deemed, there's a lot of bad facts in this if you're on the defendant side. So capitulation in this case might be a proper choice to save money and maybe save yourself, period. All kinds of anxiety and stuff and a lot of money. So that's the first one. That's the David Reichman order. The other order relates to, and I think this was entered on April 1st, if I recall. And this is between the receiver. Obviously, when I say the receiver, it's the receiver buying through his counsel regarding GTII with a non-party, and non-party is Justine Reichman, and also referred to as Miss Reichman. So she's a non-party. So in essence, she's not a defendant in this action at the current time, but she was involved because apparently she's connected, amongst other things, with .8, and that's an entity we have heard about before that I think ended up being determined. I think the question was asked, who is .8? I think the receiver would claim, and I shouldn't be speaking for the receiver, but I might claim that they're a subsidiary of GTII and that, anything they have belongs to GTII. And they have a bunch of shares, apparently, and some money. And apparently, although I was not involved with this, subpoena was served. They didn't comply, or they didn't comply adequately. And then there was further discussion. And then there was a contempt proceeding set up. And then I think there was some compliance. And then there was a further hearing set. And then there was some agreement reached. And that's kind of what this April 1 order apparently talks about. And in it again, I just mentioned the receiver does assert that .8 was created as a subsidiary of GTII and remains a subsidiary of GTII. And it may be a case there's a bunch of these, and those are the owners of shares. And, this might be reflect about what's going to happen in the future. And I would presume, especially if these guys, it appears, are starting to roll over, that others may do the same, because if you are in the same situation, but the big guys have basically capitulated to the claims, then why, if you're in the same or worse position, would you spend a bunch of money in legal fees to accomplish a negative result? It's not like if you delay and you get to keep shares that are non-tradable, that's beneficial. I don't see that. So I think if in fact there is the return of shares, that others will capitulate because they won't want to incur the legal fees. And it appears that this I see as an example of that, where somebody has agreed to the return of stuff, including the return of shares, without the necessity of having to go to trial or anything like that. That's a good thing, just like I said with the first one, because it saves money, legal fees, and if you can get an agreement, then that's great. And so that's the first part of it. And so in essence, what happens is there has to be a transfer from .8 of all of the shares, and there has to be the transfer of all monies from a fidelity account. And this is notwithstanding that they're not giving up their rights to dispute this, but yeah, I understand what they're saying, but in effect, in my mind, from a practical standpoint, they are kind of, once you give up control over an asset, it's tough. It'll be a tough row to hoe to get it back. That's my opinion. So transfer. So here we go. Transfer any and all account balances and GTI shares of .8, including but not limited to .8 bank accounts and brokerage accounts, inclusive of Fidelity account, and there's some number. And there's a description of all the accounts. So that's asking for all the accounts. And that's to a receivership account that has exclusive access. So in other words, after that is transferred, and that's the agreed upon order that's been signed off by the judge also, to do that transfer. And then all shares that they have, all common shares that are held by the transfer agent in the name of .8 shall be transferred to the receivership estate, and that Ms. Reichman will produce any documents and records in her possession related to .8 that have not otherwise been provided to the receiver by Ms. Reichman, including but not limited to all the documents specified that are referenced basically in the subpoena and are referenced here at Section 7. And pending further order from the court, Ms. Reichman shall take no further action on behalf of .8. Until further order of the court, GTI should then be responsible for what goes on. So I found that interesting. So that's transfer of shares, bank accounts, etc. And the other part of it also that I found interesting was that also, and this is in the publicly filed order, and it says, Ms. Reichman, that's referring to Justine Reichman, shall also deliver to the receiver the balance remaining in Wells Fargo account blank, which contains, and remember I referenced before the monies that were going to be used to, or the monies that were owed to the contractor with regard to the condo. And I don't know if it's the same condo or a different condo. Same address. I think it's the same address, 105. Yeah, I shouldn't mention that. I think it's the same address. Let me actually, while I'm here, let me see if it's the same address. So on instant replay, I don't see it off the top of my head. I should see it. Yeah, here it is. Yes. So yes, it is the same unit. So we're talking about the same unit. And in this, now, so this is a different document that was filed by the court that was agreed between, in this case, it would have been Ms. Reichman's counsel. Probably Mr. Reichman's counsel would have to object, and obviously with the receiver's counsel. But it would be Ms. Reichman shall also deliver to the receiver the remaining balance in the Wells Fargo account, which contains monies which Ms. Reichman asserts were for the renovation of a condominium located in LA County, which is that same condominium that has the Liz pendants on it for David Reichman. So that's an interesting question. Why Mr. Reichman is there and there's monies in this account, but those monies are going to be coming forward. So that's what when I said it referenced those monies in the other, that there's some balance, because it appears that those monies the contractor's work will be covered by monies that will come from a particular account that Ms. Reichman apparently has or had authority over. And then there's some other stuff, but that's basically it. So I believe this, by the way, is not the conclusion of these negotiations. This, I believe, is the beginning of that. This concerns just the .8. And I think, they're like on the petals of a flower. I think they're going petal by petal. And this is where they're at. And again, the Justine Reichman crowd could have fought this and caused us to incur a lot more in legal fees. Luckily, they did not. Obviously, the facts are the facts. I think these facts are really, disastrous. And maybe they realized it too, or at least their counsel realized it and counseled them as such. But this is the current agreement. I'm expecting future agreements, and it'll be interesting to see as to both of these parties how it will work out, how it work it out as to David Reichman and his shares and other stuff and what he ends up doing, and also as to Justine Reichman, the issues that we obviously have raised in the past that are not involving .8, but obviously her own shares, and we've also talked about real property also as to that. And we'll see how that plays out. But obviously, this is another good first step. So those are the two orders. Good progress made by the receiver on both, and one property tied up, shares returned, money returned. I think I speculated, and still speculation. I think I speculated in a tweet during the week that about 9 million shares had been returned. I don't know. Nobody's specifically corrected at me about the number of shares that were returned from .8. It may be less than that. But I also said it was more than $250,000. And after reading the order, I think it's probably, more. I think it's more than $500,000 that was obtained. And I don't have the specific figure, but based upon seeing this information here, especially that there was money that was set aside for a large renovation, I'm expecting that it could be substantially more than $500,000. I mean, I don't think it was, substantially more. Could that be 520, 530? I don't know. But I think when I estimated 250, I think I was underestimating and be conservative. But all this stuff is ongoing. And this is aside, again, as to the AIversity side, it's been their position, and I can't speak for anybody, but I've heard this said that's obviously essential for them that these shares be dealt with, and they don't want to be partners with anybody. And so here's some activity that goes towards that. So let's hopefully it will be able to be continued in that vein and be done quickly and inexpensively. I know our counsel in the action, who's been involved with a lot of receiverships, has commented very recently, within the past week, that he's very impressed, and I'm not making this up, so this is not BS, but he's been very impressed with the receiver and his diligence and the speed at which he's been able to recapture assets. So I'm telling you what our counsel says. And the other part is, receiverships are tricky, and I've stated this before. A lot of receiverships I've been in, and a lot of them were related to like real property and like multi-family housing, etc. A lot of those receiverships burned the assets of the receivership and ended, really, in the end, it was really just the receiver and the receiver's attorney that made out. This case, if you recall, the receiver took a different route and is basically on a contingency and is in essence a partner with the shareholders. And the more he brings in, the more he makes. He doesn't make a set fee. So, theoretically, he has a interest in bringing in as much as he done. And our guys think that he's done a great job. And in fact, they specifically said that this is the rare case where in a receivership that the company and its shareholders can actually succeed through the receivership. That's not an exact quote, but pretty close to an exact quote. In other words, it's usually difficult with the receivership, but they've been impressed. So I'm just passing along what I was told. I'm not going to state they've had more experience working with those guys directly, so I will leave it up to them and just pass on how they believe. The last point I was going to raise was the audit, and there's a question that we all should be asking about the audit. Where's the audit? Because we know the audit is necessary before this can possibly trade, and we are hoping that the audit's going to be completed quickly. And I know that everybody related to Borgers kind of I look around, especially after Borgers and accounting issues. It seems like it's taken a longer period since that. And I could only guess it's because the auditors are a little gun shy and probably are being a little more careful because they're going to be more closely scrutinized. And in our case, in the this particular GTII case, the added feature was also that there had been a move away from Borgers to another auditor. That auditor, in the end, did not appear to be cooperative, which is obscene, and that should not be allowed. But there's a lot of other things that are getting in the way. And then it went on to a new auditor. Now, the way these audits work, and I'm no auditor, so this is no expert opinion, like a lot of, almost like everything I say is not an expert opinion. There's like, one thing once I might have said that was an expert opinion. Yeah, when I talked about Bruce Springsteen on the being on a plane. But thinking about what they could do about the audit has to be completed and 100%. So you could be 99.9% complete and not have the audit submitted. And the reason you may not be able to submit it might be something that's outside of your control. And it might be something you have to wait for. It might be in the control of the third party. So that might be the issue. So even though I don't speak to the receiver, I don't speak to the receiver's counsel, I don't speak to the receiver's auditor, I don't speak to the IRS, I don't speak to, sometimes I don't even speak to JR, to be honest. And I wish sometimes, but as to the audits, my understanding from, triple hearsay, upside down, that we're close, very close to the end of the audit. We're just waiting for just some final dotting the I's, literally. And hopefully, because it appears it's headed in that direction, that will be soon. And then I know, again, that's a prerequisite for us trading again. I do not know how it works, by the way, once we get to that point in time. Maybe Big JR could look that up, that once you get trading again, the process, because it'd be nice to know. I'm giving you a job, Big JR or Little JR, anybody named JR, by the way, today. What's the process after a company gets their audits in fashion to re-up with whatever? Are there any other steps beyond just the being able to trade? It'd be interesting. If you don't want to do it, you're not obligated, by the way. But in my understanding is that we're not far off, and if we're not far off, that would be certainly that is a prerequisite to be able to trade again. I'm sure there's other steps that have to be taken, but that certainly is the prerequisite. And so we're close. I haven't seen anything, but we're close, and I kind of understand why it'll take a little while and how complicated it can be when you're waiting upon other people. And that's just the way it goes. And I understand also sometimes people have to be careful because they have a lot at stake. So I understand, even if we're not necessarily sympathetic, I understand sometimes why those complexities work. So to summarize, as to those three things, so we talked about the order and the lis pendens on the property in Los Angeles, in the western part of Los Angeles, involving Mr. Reichman. We talked about the agreement between non-party Justine Reichman and the receiver with regard to Dot 8 and shares and a certain amount of money that's not specified, but based upon the fact that it refers to renovation money, I'm guesstimating that it exceeds $500,000, the total amount. And I feel comfortable with that guess, saying that it exceeds $500,000. And there's an agreement to turn over a bunch of accounts, the shares, etc. And that as to 1 and 2, my understanding is just like as to everybody, that all negotiations are still ongoing as to all the outstanding issues. As to other parties, I'm not aware about anything. And I kind of wait to the extent I can till it's official in a court record like these records, because at that point in time, it's a public thing and nobody could be harmed by that. Of course, you don't want to say something about something that might be in process to interrupt that or harm that discussion. And I'm not talking about anything specifically. I'm just talking about it generally. There may be times you got to be quiet or else you're going to screw up something. So you have to keep that in mind. And the last one is the audit. The audit's, my understanding is the audit's progressing and we're near the end. So those three things are going. I expect the other thing is the Alpine thing. As of today, there's no new filing about Alpine. So to those of you who follow Alpine, the prime broker behind the apparent short position of DTCC. And before I go into that, I thought I invited, I'll pass on it. So Alpine is the, prime broker. There was an order from the DTCCCC, because I don't think there's enough C's in that name, that at one point in time said they had a concentrated short position, whatever that is, but I think it was presumed that means it was an unlawful short position. So I'm going to stop right there. The unlawful short position, DTCC. Now, I've also talked about the fact, if you recall, there was a SARS issues. SARS were those suspicious activity reports, and Alpine was just expelled, or their expulsion was just affirmed by the national, I'm making up the name, but it's something like the FINRA, National Adjudicatory Council, and they affirmed their expulsion, and they found that they'd committed, all kinds of prior misconduct, and because they had, in effect, and this is my choice of terms, it may not be the choice of terms that they would use, but they said they engaged in conduct and they charged fees to people without disclosing it really, so they could be, chosen, and the fees were unreasonable and not connected to anything. And then they started pulling the money out of accounts, etc. And at that point in time, they said that was sufficient to garner expulsion. But going back to what the DTC said, was they said there was a concentrated short position. So in this new thing in which they expelled Alpine, they referenced those SARS reports, which are supposed to relate to terrorism or crime. And they referenced from 2011 to 2015 that the violations weren't about like selling drugs or whatever. They involved settlement process involving microcap stocks. And they didn't specify whether those were settling. And a lot of them involved if I recall, I may be wrong, if I recall, a lot of those involved Scottsdale securities, through Scottsdale Securities, and a lot of those, I believe, are either owned by or connected to, or some are with John Hurry, because one of the things that occurred in the expulsion proceeding was one of the aggravating factors was a payment to Hurry's company for CAM charges that didn't exist, or at least seemingly didn't exist. But these SARS things that happened 2000 through 2015, and they didn't investigate beyond that, involved potentially shorting. And the DTCCC said in, I think it's 2021 or 2022, they had a concentrated short position. So I don't know if from 2015 through all the way 2022, and I don't think it was ever investigated by FINRA. Of course, why not? From 2015 through 2022. So if they were still doing the same practice, it might correlate to why they had a concentrated short position in Alpine in 2020, because nobody was watching them, and perhaps and I'm speculation, but perhaps they were engaging in the same practices they were involved in, not disclosing these micro cap transactions that involved at least arguably inappropriate practices. I think it's stronger language than that. But I would think it'd be interesting to correlate those any SARS violations with the timing of the concentrated short position to see if they continued. And I don't know if you could FOIA those. Perhaps you could FOIA those, whatever. And I know I've told Curtis this. Curtis is now MMTLP. I know I've referenced Curtis this, and I know he was interested in it. I don't know if he has had an opportunity to spend 3,000 hours looking at it. But comparing like the SARS reports in other tickers, including MMTLP, but it might be all stocks that were shorted. The point being that I don't think we understood before that the SARS reports might involve shorting transactions also, and that might have been a category that was included. And perhaps up till now, the SARS reports has not been an area that's been scrutinized carefully enough by all us guys, and perhaps in the future it will be. I know that Curtis is, and I'm certainly sensitive to that. I would like to know what happened as to Alpine FINRA after 2015, why they didn't look, and I'd like to see the records myself. I obviously have an issue with Alpine being able to spend tens of millions of dollars in legal fees. I kind of speculate on that and estimate, although nobody's arguing with me. When they're not doing like big business and who's paying those monies, it makes you wonder who is the financial source for financing and I mean, these are expensive. When you file stuff with multiple firms with the Supreme Court, I mean, that's expensive stuff. So I don't know who's financing that. I don't know if it's an outside entity. I noticed that in the filing, so they filed, now I'm referring to Alpine, being they filed something with the Supreme Court where they're challenging the expedited expulsion, which is a different proceeding. And they used, I think, 2 or 3 firms in that filing. I think it was an aggressive filing, so it wasn't like somebody was watching. Didn't look like somebody watching their dollars. It'd be interesting and I don't know why this has never happened. Also, why there's not been any further audit of them, especially in the status they are, the financial condition that they are. How does it make sense for them to be able to pay the money? Where does it come from, et cetera? Maybe the SARS reports are different. So they have the expedited expulsion proceeding, and they have a request, and this is a little bit redundant, but I'm going to say it because I think it's a confusing area, and I try to say it enough so it won't be confusing. There's 2 expulsion proceedings. One's the expedited expulsion proceeding, which involves their violation of a expulsion order and a cease and desist order that they violated. That caused FINRA to then seek an expedited expulsion order. It was anything but expedited, and that is now before the U.S. Supreme Court, and Alpine is arguing that just the denial of their constitutional rights should end up eradicating FINRA. Separate and apart from that, at the end of March, and I'm make up a name, the FINRA National Adjudicatory Council, which is the appellate section of FINRA. So there's a section that there's a hearing panel that basically serves as a trial department. And after they render their decision, then there's an appellate department that reviews those decisions. And in this case, the National Adjudicatory Council only took a mere 3 years to issue their decision. And their decision is done. They just take the evidence that's provided to them. I think it's de novo, so they could rule differently, and they did slightly. De novo means they're not bound by the decision of the trial court. They could adjust that decision. They did. In the appellate section, think they reduced the fines. They found one section to be not have been found, but they held the biggest violations. But from there, it took 3 years for the appellate section to hear that. And now that appeal that was confirmed will become the order. And that's an expulsion order that's different than the expedited expulsion order that's now before the U.S. Supreme Court. That will become final unless within 90 days of the order, and the order was issued, I believe, March 25th, they appeal to the SEC. If they appeal to the SEC, then they'll likely get a stay, and then we go on the merry way. And then there'll be a hearing at the SEC, and the hearing at the SEC, the trial there will be de novo again. De novo being, and it depends how you interpret de novo. De novo means they're not bound by the prior decisions. So there was 2 prior decisions. So the SEC themselves could come to a different decision. In some areas of law, de novo also means that you can present different and new evidence. And in this particular matter, when they started the proceeding, it happened originally, I think, during COVID. So let's say the misconduct happened in 2018. The first proceedings happened in 2020, and COVID, they did their thing. They managed to do their hearing. They got the result 2022, and the Judicatory Council gave their ruling in 2025. So now, although they have an appeal before the U.S. Supreme Court, the issue, and they asked for a stay, Chief Justice Roberts said no, and they said they needed to stay because there was harm, because their constitutional rights had been violated. Roberts, although he didn't say it, obviously disagreed because they hadn't been expelled yet. I did a couple of videos on that, I think before and after with JR and whatever. So now, since then, they actually got expelled. And unless they take action before the SEC, that expulsion will be final. So I expect, and I've said this before, I expect them to file another petition with the U.S. Supreme Court and argue that they've been expelled now. And amongst other arguments, and I've stated this, and I have tried, and I will contact them directly. But there was a case last year, and I hope this is not so boring. It's pretty boring, but I hope it's not so boring. There was a case last year in JR, and I filed it. It was called Jarmessi, whatever it was. We could never figure out actually what the name was, but it was some broker that got, I think it was a broker, got in trouble with the SEC, and they went after him for some claim, kind of like fraud, and they didn't give him a jury trial. And he went after them amongst other reasons, a bunch of reasons, including that. And it went up, and the U.S. Supreme Court said that if there's a certain kind of claim, not like a statutory claim, but a common law claim. And what's a common law claim? If you go back to England 400 years ago, if you stole something, that was you were entitled to get relief in the courts. Or if you committed fraud, you were entitled to relief. Those were things that existed long before statutes and all that. So in Jarmessi, the court said, if you, being the SEC, go after these guys for common law claim, and you're seeking money, then they're entitled to a jury trial, and the SEC has no jurisdiction to do this. So that's a big deal, right? So in Alpine, we've only been at FINRA. We've been at the FINRA level. So we haven't been at the SEC level yet, but we're going to the SEC level. And the claim and this is the argument, one of the arguments I would certainly make, and I would expect to see, the FINRA, the claim was for violations, and in essence, it was conversion, misappropriation, theft stuff. Theft is common law. In other words, if you stole something back in England 400 years ago, there was a remedy for that. So it's, in my opinion, it's common law. So, and the SEC gets to consider this stuff de novo. In other words, they're not bound by any of the decisions of FINRA. So they get to look at it again and be completely unbound. So in essence, it's like a new trial. There's also an issue. There was a request in the underlying proceedings to put on additional evidence that was denied. And I'm sure they're going to ask again. And if there were an additional evidence that were allowed to be provided, that might make an even stronger argument that there's a new trial. But I think I feel comfortable that somebody's going to make an argument that this is like Jarkessi. And once it gets to the SEC, since they have to review it independently, that it's a new trial based on a common law seeking money damages. And as such, they're entitled to a jury trial, and the SEC has no jurisdiction, and they can't rule on it. And hence, then, since there's no review by the SEC, it's probably a violation of non-delegation doctrine and a whole bunch of other things. And I think, in large part, at that point in time, first of all, I think FINRA would be in deep trouble in terms of its existence in its current role. And I believe, as I've hoped, the SEC's enforcement powers would be limited because perhaps they couldn't, all these would have to go to federal court, Article 3 courts. The SEC in its slow molasses process wouldn't be allowed to, slow the world down. Remember, I just kind of think about the time frame. So we're 2017 is the misconduct in Alpine, 2017, 2018, first filing to 2020, the first decision, 2022, a confirmation of that decision, 2025. So we're 7 years in on conduct that should be cause for expulsion because that's what they said it is for. And we haven't even got to the SEC. And now we're going to I know we're going to face an issue with the Supreme Court, whether it's before or after. So if, and I am expecting this, if they file another petition with the Supreme Court, if the Supreme Court should turn down that petition, and should there not be another case that gets decided in the interim, I would expect that if Alpine's expulsion gets affirmed by the SEC, that they would take it up again, based upon a whole bunch of reasons, including, lack of fair process, non-delegation, lack of jury trial, Fifth Amendment, and I think they just attach a copy of the Constitution. Now, as you know, I hate Alpine, but if that can be the means to get rid of FINRA and limit the SEC's power and get them more easily handled by the courts, I'm all for that. And again, courts are slow, but not 10 years. You don't file an action in federal court. It's not going to take you 10 years to get up to a meaningful level. It might take you 3, 5, somewhere 3 to 5 to be all the way through, but not like this nonsense because we're not even close to the end the way these guys are handling it. On top of that, and one last thing, I've been meaning to say this, and since it just popped in my head, I'm going to say it now. I also believe, as opposed to digging around, and that's with a capital D, with these proceedings in which they're protecting their own power base, and I know I'm referring to the SEC and DOJ, and in light of the fact that we've been able to do it, right? We've done this. So why can't the feds put Alpine into receivership? It makes no sense. We're a bunch of screwballs. We're able to kind of somehow, without the resource, I think the U.S. has more resources than the GTII community. Maybe I'm inaccurate. Maybe we're more, well, we certainly are more resourceful, obviously. But in terms of financial resources, manpower, lady power, money, etc., we have nowhere near the capacity. So why in heaven's name haven't they gone in, tied up Alpine? Listen, just like in the receivership reports that we've seen, the government has made the case that Alpine has acted improperly to the extent that they shut them down, and they try to shut them down multiple times. So if they're right, why not go into federal court, get a receiver to take them over, and if they have been wronged, then they will be able to operate. And if not, they can't do any more shenanigans. And the receiver, of course, would be able to go in there, engage, and figure out why and how and if they should be spending these millions of dollars in legal fees, right? Isn't that the big issue? If they're not spending all these legal fees, then we're way down the road. And if you had a receiver in, and they would have the powers to decide what should be spent and what not. They wouldn't be the authority of the existing management, notwithstanding whatever. And there would be a big fight, perhaps, but that big fight might disclose a lot, or somebody might bail completely, or lots of good stuff can happen. So I urge, and whoever it is, Doge, the White House, the Greenhouse, whoever it might be, have the SEC and FINRA get out of the way, take these guys to federal court, give them due process, set up a receivership, let them prove that they're great guys, and that everything that's happened over the past 40 years, a lot of what they've admitted to, including the issue about, if you recall, the issue about the gentleman who was I go back to this because, I find this record, appalling, but this is like the best description to me of who we're dealing with. But I go back to their attempt, and I think it was 2015 or 2016, this gentleman begins to work for them. He's, I think, a law clerk going to law school or something like that, dealing with regulatory compliance. So he dealt with the regulators, which is always interesting to know. And I think in 2016, and again, I don't know if this was the first, last, or whatever, he got into trouble by molesting a young girl. I don't know how old she was, but under 16 years old. And I know that it's, factually true because the information is, and no one has countered this, that he was admitted to and convicted of a felony sex offense. And he disclosed that to his bosses at Alpine or the related company. There were some subsidiaries. So I think he worked for both, and at least worked for Alpine at some point. And I don't know who he disclosed it to all at once, but at some point in time, they became aware of it. Despite that, they applied to make him a point man representative of the company on behalf of Alpine. In that process, he disclosed that conviction. They said you're disqualified because if you grope underage girls and commit felonies, we don't allow you to be brokers. They actually did not say that. They should have said that, but they declined. But you have an opportunity at that point in time either to appeal that decision, and this is with full knowledge at that point in time. Everybody knew. This is not like a secret. Order had been out. So everybody at Alpine knew at the time they appealed the inability of this person to be their representative. They moved to overturn that denial. And at that time, the options were to appeal the denial or to withdraw it. I don't remember, it was a withdraw, was the specific process, but in effect, it was to withdraw the application. They elected to go forward. It was eventually denied. His application was denied. Anyway, but that was the caliber of the person that Alpine was seeking. So at this point in time, I highly approve, will support Alpine's efforts to extinguish FINRA. I think they have an interesting case. I will support it, even if it requires me to file a amicus brief. I will support it. But as soon as it's done, I also will support any and all efforts and lead any and all efforts to get Alpine's position with whatever entity they have at that point in time terminated, if it's allowed. In other words, if there is a justifiable reason that they shouldn't be allowed to engage in further business, I will support that, help anybody, and I presume it'll be on the same basis that I know, and we'll go from there. So that was an hour. I honestly wanted to do like 15 minutes. I will be doing another one, I think, tomorrow, and I'm going to talk about tariffs. At least that's the idea. And if you have questions after this goes up, if a lot of this stuff doesn't make sense, join the crowd. A lot of this stuff doesn't make sense. But I expect that, because of the interesting events that have occurred in the economy of recent times, that maybe we will see some movement on some of these things. It'd be interesting to see. I will, again, be talking. I'll try to do something tomorrow, talking about tariffs and things, and maybe more on this. And I will be doing a live stream with JR sometime early this week. And I invited, I think, I'm going to make this a pledge. From this point in time, if your name is Hoffman and you're watching this, please let me know and I will invite you in to speak. We're going to start off if your name is Hoffman. Then if a relative of yours is Hoffman, then if a friend of yours is a Hoffman, and so on and so on. We'll see what we can do. We'll see how the Hoffman channel will work out. Anyway, thanks to all of you who spent this hour with me on this pretty complicated fact setting. This is kind of like a law school factual setting with the two expulsion orders and different expulsion orders and stuff up in the Supreme Court. And when you go to law school, by the way, and I'm sure JR would acknowledge this, unless you're going to be a con law lawyer or a professor, you think you're never going to look at this stuff again. It's kind of like, algebra, geometry. In the real world, how many times have you done factoring since you've been out there? A lot of stuff you don't use again. And it's kind of funny. This con law stuff is, and the security stuff is really entertaining, interesting, and stimulating. And hopefully will be useful for a positive resolution. So we shall see. Again, all you that out there, I appreciate you all. I hope you all have a great day and a great Saturday wherever you are, or Sunday if you're way out there. Hello to Mushroom if you're watching, way out in a different time zone. I think you're getting close to midnight. And that's it. Have a great day. See you soon.